We all make mistakes, right? Nobody's perfect. Mistake number one, not having a plan or having a very simplistic plan like just a will and thinking that's enough. If you don't have an estate plan in place, or if you just have a will, your family's going to have to go to the courts. They're going to have to get a conservatorship or basically a court order that allows them, that gives them the authority to step in and manage your affairs. It's a very expensive process. It's public. It's painful. You got to show the court what's wrong with you. It's not a good thing. And there are very efficient ways to avoid that. The three must-haves, and I added a fourth here that I'll address later. If you have over $150,000 or so in liquid assets, and or if you own any property, you need a revocable living trust. Everyone over the age of 18, regardless of how much they have, needs to have a durable power of attorney for finances, not just a check the box form. Ideally, it should be one that's done by an expert because it can address some other issues we'll address later. The power of attorney lets you name the individuals who can step in to manage your financial day-to-day issues, your business of life issues, dealing with retirement accounts, government agencies, the IRS, advanced healthcare directives. This allows you to name the people who can communicate on your behalf with doctors, with hospitals, and who can even make decisions for you, very challenging decisions, with your guidance if you need that help, if you can't make medical decisions for yourself. I would add that if you have children and grandchildren, and if you have any assets, I would add a fourth key document, would be considering family protection trust for the next generation. And you really want to make sure it's someone who can identify issues that are relevant to you beyond just the basics. Now, better to have a simple plan that's set up properly than no plan at all, but you want to make sure that you're addressing some of the other more sophisticated and challenging issues. Mistake number two, not reviewing or updating your plan. Ask yourself, do you have the right people named as your backup trustees or decision makers? Are these people still able to serve? Are they still a part of your life? Do you trust them if they run into problems of their own? Do you have the right beneficiaries named? Do you have any protections in place for them? Do you have age restrictions? Do you have structures? Do they face any issues of their own that you should be aware of? Is your trust properly structured? This mainly applies to married couples, but the structure of your trust can have big tax implications as it relates to capital gains taxes. And are your documents up to date? Do they reflect recent changes in law? And does your plan address property, capital gains, and estate tax issues? So if you have an old plan, you need to take a fresh look at it. Will a bank even honor an old document? Old power of attorney documents that are old, as they get past 5 or 10 years old, we refer to them as becoming stale, meaning banks don't like to work with old documents. They don't trust them. Now, technically, even if it's valid, you still could run into a lot of trouble. So I would just say this, an out-of-date plan can, in some cases, be worse than no plan at all, because your situation may have changed dramatically. Now, how do you fix this? Well, review your plan with an expert who really understands this and understands all of your issues at least every 5 years, or if your situation changes, or if you see the law change in a way that might affect you, whichever sooner. So 3, failure to protect assets for the next generation. Leaving assets directly to your child is often a mistake. In fact, I would say it's usually a mistake given all the tools that we have to protect assets. Kids with a disability or with special needs, you need to create a special needs trust for their benefit. It is basically a legal structure that provides a lifelong legal and financial safety net. It's a way for you to leave assets for the benefit of a child with a disability in a way that doesn't interfere with their eligibility for government benefits. It ensures that someone or some entity that you trust will oversee these assets for your child for the rest of their life. And it prevents them from getting manipulated and losing all that money. But a failure to set this up ahead of time can result in the loss of public benefits. It might result in your loved one having to go to court to get a new one created for them, or someone else creating a different type of trust for them. It can just be a big mess. So now, what if there's not a disability, but you're worried about a child or grandchild who has issues managing money, or they have substance abuse issues, or they are subject to bad influences? Do not leave assets directly to that child. There are many solutions for different estate planning structures where you can empower someone you trust to oversee assets for those, I guess you could say, problem kids, where you can still support them, but you can be sure that money doesn't disappear, that it's not taken by bad parties, it's not used for drugs or partying. Well, my kid's doing fine. In fact, my daughter's thriving, making lots of money. She's doing super well. She's starting a family. Don't leave assets directly to that child who is thriving. What is a family protection trust? This is a way to protect assets for future generations. So if your child divorces, if you leave assets to a family protection trust, there is protection from spouses in the case of a divorce. It keeps assets separate. If your child is sued, assets in a family protection trust benefit from a high level of protection against litigants. That can save millions of dollars potentially in a lawsuit. And when your child passes away, if you leave assets to a family protection trust, those assets, with some limitations, are not part of your child's estate. They are not subject to estate taxes when your child passes away. And you might think, well, this is great, but I don't want to tie my kid's hands. They can be their own trustee. These trusts last for about 100 years in California. So protections for 2 to 3 generations. You do not need to be ultra high net worth for these to make sense. So I want you to be aware of these tools. Special needs trusts, family protection trusts, but there are a bunch of other structures that can be set up to protect future generations. 4, failure to address property or estate tax issues. If you own even just your home in California, you need to be aware of the impact of Prop 19. This means that if you've owned your home for a while already, your children will almost certainly face a massive increase in property taxes when you pass away, unless you plan. If you own a house in the Bay Area, your house alone could mean that you might face estate tax exposure in the future. The exemption, the amount you can pass tax-free, is very high right now, but it's going to drop on January 1st, 2026. It's a punishing tax. It's 40% of any dollar over the exemption limit. If you've owned a home in California for over 10 years and want it to be available to your children, you need to work with an expert on property tax solutions. And this is a very narrow range of attorneys and firms who understand that. If you're single and your estate's over $4 million today, if you're a couple and your estate's worth over $8 million today, you need to be aware of this because it is very likely you're going to face significant exposure in a few years. Mistake number 5, failing to coordinate and communicate. You want to have a coordinated financial and legal plan. And what does that mean? Well, it's making sure that one hand is talking to the other, your financial advisor is talking to your attorney. If you manage your own investments, it's really important for you to even be more closely aligned with your estate planning team to make sure you're doing things properly. You got to coordinate, communicate, and make sure that one hand is talking to the other, that the people named in your documents know that they're named, that you verified they're okay serving, and that they know generally what to do. Make sure your financial planning is integrated with your legal planning as much as it can be, making sure title assets are properly titled, that beneficiary designations are coordinated, that one hand is talking to the other. So if an issue comes up, if you're getting close to some of these key tax numbers, we can all work as a team to help you solve these problems. Communicate with your backup trustees, communicate with your family whenever possible. I know that in some families, that's a fraught thing. If there are challenging family dynamics, we can't always do that. Gilfix and the Paul Associates, we are true pioneers in the area of estate planning and elder law. 40 years in Palo Alto. We're very proud of that. We've served thousands and thousands of families throughout the state of California, from San Diego up to Wairika. So we've seen it all. We've served so many different types of families from all walks of life, from just normal everyday people to Nobel Prize winners and to CEOs, but everybody across the spectrum. And I love meeting people from all walks of life, and we can provide value really to everyone. We've saved hundreds of millions of dollars, if not more, in taxes for our clients. But most importantly, our mission and our goal is to empower you and to provide extraordinary value and peace of mind. We're very proud of our place in the community and our place in the legal world. Thank you, thank you, thank you. Check out our other videos. I hope we get the chance to work with you, but regardless, I hope you got a lot out of this video. I'm Mark Gilfix. Stay safe and healthy.